For a long time, the worst-case scenario for a construction supervisor was losing their job. Today, it's a federal prison sentence. For the past 4 decades, the industry operated under a predictable standard. If a fatal accident happened on a job site, the corporate office stepped in, negotiated a civil penalty, wrote a check to regulators, and the project moved forward. That system is over. The Departments of Justice and Labor launched the Worker Safety Initiative, a joint mandate explicitly designed to bypass the corporate entity and target individual supervisors. Federal prosecutors no longer view ignored job site hazards as administrative errors. When a site manager overlooks a safety protocol, investigators treat the site as an active, deliberate crime scene. Take a common dirt operation. Sending a crew into a deep, unshored trench is now prosecuted as criminal endangerment. The corporate shield is dead. As a site superintendent, you are now the primary legal target of federal worker safety investigations. Historically, prosecutors were frustrated by the Occupational Safety and Health Act. Under that law, a willful violation that directly causes a worker's death is classified as a Class B misdemeanor, carrying a maximum sentence of just 6 months. To bypass that statutory limit, the Department of Justice formally transferred worker safety prosecutions out of civil enforcement and into its environmental crime section, granting investigators access to much harsher federal statutes. Local district attorneys are taking the exact same approach. State prosecutors are now pursuing direct criminally negligent homicide charges against supervisors who ignore hazards. We can see the results in recent cases in New York. In Manhattan, excavation foreman Wilmer Cueva ignored multiple direct warnings from a safety inspector before a fatal trench collapse. Across the river in Brooklyn, site operator Jimmy Liu ignored repeated warnings about an unsupported excavation wall that eventually fell and buried a laborer. The courts did not let them hide behind their companies. Both men received 1 to 4 years in state prison for those preventable deaths. Even if you do absolutely nothing to cover your tracks after an accident, gross negligence on a job site now results in direct, personal criminal liability and prison time. But the real legal danger often occurs in the immediate aftermath of a fatality. In those high-stress minutes, a panicked superintendent might try to manage the situation by altering the physical scene or fixing the paperwork. In a case involving hospitality builders, a worker suffered a fatal 40-foot fall from a pitched roof. Site Superintendent Robert Kennedy made a critical error. Before OSHA investigators arrived, he instructed a subcontractor to place fall protection harnesses on the roof to make it look like the gear was in use at the time of the accident. A similar situation unfolded with Northridge Construction Superintendent Richard Zagar, following a fatal fall from an improperly secured metal shed roof. Zagar lied to federal agencies about the structure's stability. Those false statements escalated a civil regulatory inquiry into a felony obstruction indictment. This chart compares the maximum prison sentences for different workplace violations. As you can see, a standard OSHA violation maxes out at a 6-month misdemeanor. Lying to an investigator or tampering with a scene triggers Title 18 federal felonies, which carry maximum sentences jumping up to 5 or even 20 years. Prosecutors apply these charges to any form of documentation fraud. If a food safety superintendent backfills daily sanitation logs to hide explosive grain dust accumulations, that paperwork discrepancy is prosecuted as felony obstruction. Lying or altering a scene to manage the fallout of an accident is exactly the leverage federal prosecutors rely on to secure a long-term felony conviction. You might assume your company will protect you if investigators show up, but the Department of Justice has engineered a corporate enforcement policy specifically designed to break that bond. The framework for this approach was built over several years by top justice officials, starting with Deputy Attorney General Sally Yates, who rewrote the rules of corporate legal defense. Current Deputy Attorney General Lisa Monaco reinforced a strict mandate. For a corporation to receive any leniency or cooperation credit, they are federally required to swiftly hand over all internal evidence that implicates their own individual employees. When a fatal accident happens, your employer, corporate counsel, and the company's insurance providers are strongly incentivized to save the corporate entity. They will actively help the government build the criminal case against you. Blind loyalty to a company schedule is legally suicidal. The government has ensured that when the pressure is on, the corporation will abandon the individual. There is exactly one way to survive a targeted federal audit. You have to build a paper shield. Contemporaneous, highly specific documentation that proves you prioritized safety. When you spot a hazard, you must physically halt the work. Then immediately record the exact safety reason for that stoppage in your daily logs. If a project manager or owner decides to overrule your safety stoppage to hit a schedule, you must obtain written proof. An entry explicitly stating that work was halted due to a lack of shoring, but was overruled by management, is your only defense. Routine, vague daily log entries detailing generic weather conditions or head count offer zero legal protection during an obstruction investigation. Stopping the clock on an unsafe hazard and documenting the unvarnished truth is now the only mechanism standing between a site superintendent and a federal prosecutor.